Originally, I worked at a small paper in Kankakee, Illinois, and eventually I landed a job as a writer with the American Medical Association. They have a big meeting in December each year, and they had a meeting in San Francisco, but I had to stay behind and watch the shop because I was the new guy. And suddenly I get a phone call out of the blue from the boss. We have something big happening. We need you to get down to the federal courthouse, the Dirksen building, and cover the chiropractic trial. Well, I didn't know much about chiropractic at that point. And so I did a little prep. I went down to the courthouse and I covered my first antitrust suit, Wilke et al. Versus AMA et al. And so I was writing weekly reports. It was a weekly newspaper, and I covered what happened in the order that it happened. But my bosses at the AMA were hating them. They called me on the carpet and they said, "You're not telling our side of the story," which was kind of shocking to me and intimidating, and it felt like a threat. I think the AMA bosses, they called them the boys downstairs. They were unhappy with my coverage, and I just felt like maybe my job was in jeopardy. But I followed through and I covered it the way I was covering it. What I didn't know was George McAndrews, who was the attorney for the chiropractors. He was actually clipping my news reports out of the AMA newspaper, sending them to interested parties to let them know what was going on in the trial. So very ironic that the newspaper of record for that trial was American Medical News from the AMA, and that included for the chiropractors. Well, the AMA had, in effect, spies within the major insurance companies that tipped them off. They ran the roost. They had people everywhere. People were kissing up to the AMA and warning them, the chiropractors are trying this, chiropractors are trying that. And the AMA formed an internal secret committee. Originally, it was going to be called the Committee on Chiropractic, but they felt that that was too friendly. It sounded like the chiropractic embassy within the House of Medicine. So they renamed it the Committee on Quackery. But something important happened in May of 1975, and that was emergence of a character called Sore Throat. Chester Wilk organized the lawsuit. Eventually, other people got on board. But for that to happen, he needed sore throat. He just didn't know about sore throat yet. He claimed he was a former AMA employee, that he had secret documents. Now, remember the book, In the Public Interest. Those were generally the same documents that were presented by Sore Throat. But initially, Sore Throat in May of 75 went public. He dropped off tons of memos about the AMA. Nothing to do with chiropractic, by the way. And he caused a huge stir because major newspapers, New York Times, Chicago Sun-Times, etc., started to report on AMA shenanigans. They said in documents that the AMA hand must not show in what we're doing. So they were secretive through this Committee on Quackery to contain and eliminate chiropractic. And that meant using all of these tactics of stopping them from getting funding for research, stopping them from being upgraded to get reasonable coverage by Medicare, interfering with the education process, interfering with the relationship between medical doctors and chiropractors. To see that there was an organized conspiracy against a rival profession just was shocking. I mean, people tended to think of the AMA as like the symbol of Dr. Welby, the nice, well-mannered doctor who was doing things. Meanwhile, they have a secret committee that's playing dirty tricks and, violating antitrust law. The chiropractic profession as a whole eventually became involved as Chester Wilk gained momentum. He went through a process to find an attorney who would even support the idea of a lawsuit. The general counsel for the American Chiropractic Association basically told Chester Wilk that he was crazy, that they would never win a lawsuit. It was a waste of money. It was a waste of time. And besides, he thought he was building bridges with the AMA. He was very poor representation for the profession, but he was the general counsel for the American Chiropractic Association, and he had the backing of the chiropractic establishment. Eventually, Wilk won over support from other organizations. The AMA's own documents, which were stolen, should have proved the case in the first trial. There were some other documents that were found, for example, like an unpublished study by an AMA board member where he showed the benefits of chiropractic in a war zone during World War II. They brought in leading experts from England, from Northwestern University in Chicago, to talk about benefits they'd seen in their patients from adjustments of patients. The problem was the judge in the first trial gave incorrect instructions to the jury and basically allowed this First Amendment argument to prevail. And it's interesting, the judge had second thoughts after the verdict in the first trial, and he went to McAndrews and said, you really need to appeal this because I made some errors. And McAndrews, of course, was already on it. They appealed and they won. The AMA appealed, and eventually it worked its way up to the Supreme Court, which meant that another trial had to be held. Judge Gatzendanner was the judge in that trial. It was a bench trial. She called all the shots in that trial, and she found, based on the evidence, that the AMA had indeed acted illegally in violation of antitrust laws. She ordered that the AMA publish her 100-page plus decision and send it to all the MDs in the country. AMA had seen that some sort of lawsuit was coming, and they started to change their policies so they could claim that we may have discriminated at one point, but we don't anymore. However, McAndrews had to double back and get the actual documents, which wasn't easy because they had burn bags at the AMA before the lawsuits, and they were destroying evidence. But McAndrews was smarter. He went to some of the local member associations. He figured that these documents had continued to live there, and so he found them, and he just had an excellent case. Cooperation between MDs and chiropractors, referrals, access, in some cases, to the equipment that Wilk didn't get. It was a huge victory. It was the 5 plaintiffs in the case, Wilke et al., and George McAndrews, that opened doors that were once closed to chiropractic.